Well, good morning, everybody, and thank you all very much for being here. I certainly appreciate that. I'm going to roll right on time simply because we have a lot of other committees that are meeting, and so I appreciate our panelists for being here. This Congress, the Environment and Public Works Committee, has examined many issues associated with PFAS contamination and remediation, including potential impacts on public health, liability issues, and the EPA's regulatory responses. I've seen firsthand the impact of PFAS contamination in my home state of West Virginia, and I'm going to continue leading this committee's efforts to protect the health of my constituents, clean up legacy pollution, and ensure the folks responsible for the contamination fund their share of the cleanup costs. Today we'll discuss another part of the PFAS problem, how PFAS cleanup and disposal directly affects billions of dollars in infrastructure investment. Project managers, including federal contractors, encounter PFAS contamination when expanding airports, rebuilding roads, bridges, and replacing water systems. Since there's not a clear framework guiding where contaminated soil should go, what standards apply, or who is liable, it becomes extremely difficult to clean up and remediate these sites once contamination has been identified. To address the liability concerns after the EPA's designation of PFOA and PFOA, PFOS as hazardous substances under CERCLA, the agency issued an enforcement discretion policy to protect some passive receivers, including landfills, airports, and farms. But that guidance does not offer an answer the practical questions that are halting projects right now. First, the system between contractors and disposable facilities is breaking down. Today's projects face a major impossible situation. Landfills often will not accept soil unless the soil is tested for PFAS because insurance companies won't provide coverage to the landfill operator. When contractors do test the soil, there is no established federal standards to measure against. Insurers often deny coverage if any PFAS is detected, even if PFAS is below varying state standards. Second, because project managers cannot price this liability risk, potential bids for infrastructure projects just come in with huge contingencies or no bids at all. This leads to a cost premium that directly affects how critical projects are built and maintained, and those costs are passed through to taxpayers and ratepayers. The EPA can take steps now to improve how these problems are managed throughout the full life cycle of a construction project. The agency should issue clear disposal guidance to restore predictability, so contractors and landfills know where to dispose of contaminated soil. Projects need federal soil screening levels that are practical and implementable. Communities need guidance on managing PFAS in groundwater, stormwater, and treatment systems. We also need to address the root cause of the contamination. PFAS hotspots, such as military sites and airports, are a major source of the problem. Without limiting contamination in these areas, PFAS will keep seeping into water supplies, leaving communities with a forever drinking water problem. For locations with the highest concentrations of PFAS, we may need disposal options beyond containment. The good news is that the destruction technology is here, and the EPA has validated that process through thorough testing, showing that PFAS can be destroyed at levels above 99.99%. That technology is expensive, which is why EPA needs to issue guidance to determine what management approaches are most appropriate. Liability issues must be addressed. The EPA should provide predictable pathways for good faith actors using the proven bipartisan model established under the brownfield cleanup process. When CERCLA liability slowed brownfield cleanups, the EPA used administrative settlements to protect innocent landowners and local governments. That same authority exists today. The EPA's April 2024 enforcement memo on PFAS enforcement explicitly contemplates settlements with passive receivers to protect those entities from third-party claims. These settlements close the liability gap that enforcement discretion leaves open and ensures that polluters pay. Administrative settlements are a critical interim solution, but case-by-case agreements are too slow to fully address a nationwide challenge. Recognizing the limitations of EPA's administrative authority, Congress must provide a permanent statutory solution through the 2002 Brownfields amendments. This statutory fix removed the burden of case-by-case settlements by providing lasting legal certainty. This model is a proven framework for good governance, and it is the model we should consider for PFAS. Congress must come together to enact a bipartisan solution to minimize future PFAS contamination, develop a clear path to destroy PFAS, and protect passive receivers. I'm committed to working with members on both sides of this aisle, and I look forward to hearing from our witnesses, and I will now turn to our ranking member, Whitehouse, for his opening statement.
Thank you, Chair Capito, for this hearing. Welcome to all of our witnesses. PFAS is a public health menace. These dangerous chemicals have been widely used for decades, despite the harm they cause. Pandora's box has now been opened, and these forever chemicals are here to stay in our water, our food chain, and our bodies. Chemical manufacturers and other polluters will try to pass the responsibility of managing the risks onto the rest of us, but that is neither fair nor right. The Superfund law is the best tool we have to hold polluters accountable. The retroactive joint and several liability framework is crucial to its success. If you are responsible for the release of harmful chemicals, you are also responsible for cleaning them up. That's something our moms mostly taught us. The manufacturers who profited off PFAS while Americans got sick should be held responsible. If there are other responsible actors, EPA or the manufacturers can properly seek payment of some of the cleanup costs from these parties. However, manufacturers should not be able to abuse the law and aggressively use third-party suits to avoid paying their fair share. EPA has the authority and the tools to clean up contaminated sites while protecting those who have acted responsibly. EPA has discretion when it comes to recouping cleanup costs, and it can provide contribution protection through settlements. This is what the enforcement discretion memo from the Biden administration did. But it remains to be seen how the current EPA will enforce the law, or if they will continue writing a blank check to industrial polluters. PFAS and PFOA should remain hazardous substances under Superfund, but the process cannot stop at the designation. We need research to identify safe ways to destroy or dispose of PFAS without creating newly contaminated sites. That research was already underway at EPA's Office of Research and Development, but Administrator Zeldin recklessly shut the office down. Funding is needed to remove PFAS from drinking water and the environment, but the Trump EPA wants to slash the state revolving funds that would pay for it. Communities need guidance on handling, testing, and monitoring PFAS to ensure they stay safe and healthy, but thousands of EPA employees have been pushed out of the agency. EPA's responsibility is to protect human health and the environment. But again, we see evidence of EPA abdicating that responsibility and taking up its new mantle as polluter protection agency. I welcome hearing from our witnesses about EPA's authorities and where there are gaps in responsible remediation of PFAS. If there is a role for Congress to ensure that the right people pay to fix this problem, then I look forward to working together to find a solution. And if I may add on a different point, Madam Chair, I just returned from the climate COP in Brazil, in Belém, as an official CODEL of one. Many of us travel on CODELs, and many of us are accustomed to having the State Department provide basic logistical support for our CODELs. In this case, the State Department refused to provide any logistical support whatsoever for this CODEL. No officer, no connection, no facilitation of anything. Even my credentials at the CODEL, they refused to facilitate. I had to work through private organizations for every aspect of this trip. I have never seen that happen before, and I think it's a very unfortunate new development. It is deliberate. Here is the statement of the State Department about this. The Trump administration refused to use taxpayer dollars to send or facilitate any official travel for this conference. They did it on purpose. So for those of you who plan to take CODELs, beware of this. For those of you who foresee the prospect of a Democrat administration one day? Should that Democratic administration refuse to provide any support or facilitation for your CODEL because they don't like why you're going or where you're going, just know that that started here. Best would be to stop it here as well before it becomes a reciprocal tit-for-tat piece of executive versus legislative combat or disservice. Thank you.
Great. Thank you, Senator Whitehouse. And we are now going to turn to our witnesses for their opening statements. Our first witness is Eric Gerstenberg. Mr. Gerstenberg is the co-chief executive officer of Clean Harbors. Clean Harbors operates hazardous waste management facilities across North America, including permitted incinerators that have participated in EPA's testing to validate PFAS destruction capabilities. Mr. Gerstenberg, welcome. You're recognized for 5 minutes. Thank you for coming.
Madam Chair, Ranking Member Whitehouse, and members of the committee, my name is Eric Gerstenberg, and I am the co-CEO of Clean Harbors, the nation's leader in environmental services. My testimony today draws upon our 45 years of experience in delivering a broad range of services, including hazardous and non-hazardous waste management and emergency response. I will summarize my written statement and respectfully request that my full statement be included in the hearing record. Thank you for the opportunity to address the intersection of hazardous waste management and the challenge of emerging contaminants, and more specifically, the Resource Conservation and Recovery Act, or RCRA, and PFAS, forever chemicals. RCRA was enacted in 1976. Before that, the landscape of waste management was vastly different than today. Across America, hazardous waste was often disposed of in open dumps, abandoned lots, and poorly constructed landfills. Drums were left to rust and leak and contaminating soil and groundwater. Environmental disasters were common. RCRA changed all that by establishing a comprehensive federal framework for the safe management of hazardous waste. Today, we face new challenges. PFAS compounds were used for decades in firefighting foams at places like airports, firefighting schools, and military installations, and also in coatings, consumer goods, and other applications. The presence of PFAS in groundwater, soil, and drinking water is widespread. It is a growing concern for regulators, communities, and industries alike. The science is clear. PFAS does not break down naturally and is a serious threat to human health. At Clean Harbors, we believe the existing RCRA framework provides the tools to manage PFAS safely. We have operations in all 50 states and Canada with vast transportation network and facilities strategically located nationwide. Our company operates 10 RCRA-permitted high-temperature incinerators in 7 hazardous waste landfills. Our 360,000 customers include Fortune 500 as well as government agencies. Through our 25,000 employees, we deliver cradle-to-grave solutions under RCRA framework, ensuring that every shipment is tracked and every community is protected. Clean Harbors is also a national provider of critical response services. We have addressed events such as Deepwater Horizon oil spill, the East Palestine, Ohio train derailment, and the recent fatal plane crash in Louisville, Kentucky. Regarding PFAS, we introduced Total PFAS Solution, with offerings ranging from lab analytics to water filtration to site remediation and disposal. Last November, we completed our 3rd full-scale PFAS destruction testing at our RCRA-permitted incinerator in Utah. This study was completed in partnership with the EPA office and the Pentagon's military office. The peer-reviewed results of this study was recently released by the EPA, and it demonstrates that common legacy PFAS is effectively destroyed in RCRA-permitted high-temperature incineration systems at levels exceeding 6.9%, while limiting emissions to 2 to 8 orders of magnitude below any state ambient air limit or guideline. Sophisticated incineration facilities like ours provide an opportunity to address top health and safety concerns of Americans' impacted communities. For PFAS to be fully addressed, many are looking to EPA to provide a PFAS regulatory framework beyond its initial drinking water standard. At Clean Harbors, we have done extensive analysis on the PFAS contamination footprint throughout the U.S. We believe there is adequate capacity to manage PFAS contamination in the environment through the following hierarchy. Highly contaminated soils, liquids, AFFF foam should be properly remediated and destroyed in these high-temperature RCRA-permitted incinerators. Low contamination materials can be adequately managed through RCRA-permitted subtitle C landfills. Very low contaminated materials, such as construction debris and soils excavated for the development of infrastructure, which have background PFAS levels, can be managed to properly line Subtitle D landfills and deep well injection. Industrial drinking water can be treated, utilize media, and separate and purify PFAS contaminants from water, with the contaminated media being managed to high-temperature RCRA-permitted incinerators. There is adequate RCRA-permitted capacity throughout the U.S. to properly manage all PFAS-contaminated sites. We look forward to continuing that partnership and apply our diverse capabilities to address the scourge of PFAS. Thank you for the opportunity to testify today. We appreciate the committee's leadership on this critical topic, and we are happy to address any questions.
Thank you, sir. Next, our next witness is Leah Pilconis. Did I say that correctly? Thank you. Ms. Pilconis is the General Counsel of the Associated General Contractors of America. In this role, she represents more than 27,000 contractor firms across all sectors of the construction industry, including the highway, transportation, utilities, and federal infrastructure projects. Welcome, Ms. Pilconis, and welcome back to EPW. You're recognized for your opening statement.
Thank you. Chairman Capito, Ranking Member Whitehouse, and members of the committee, thank you for the opportunity to testify. I'm Leah Pilconis, and I serve as General Counsel of the Associated General Contractors of America, representing more than 28,000 member companies, including construction firms in all 50 states who build and maintain the nation's infrastructure. PFAS is everywhere, yet standards contractors need to manage it are nowhere. Because PFAS is present in soil, groundwater, building materials, and everyday products, contractors can encounter it anywhere they work. Contractors are not PFAS polluters, they are builders. Yet under the current law, they are treated as parties responsible for PFAS pollution. AGC supports congressional efforts to modernize environmental liability laws. Our message is simple. Contractors need reasonable liability protections and a clear, workable path to compliance when they encounter PFAS during construction activities. EPA has designated PFOA and PFOS as hazardous substances under CERCLA. As this committee knows, CERCLA liability is strict, retroactive, and joint and several. Fault does not matter. Intent does not matter. Knowledge does not matter. A contractor who unknowingly encounters PFAS, even decades ago, can be swept into Superfund liability. That is an untenable status quo, and one we felt compelled to challenge in court. But even without cleanup orders, PFAS is driving up project costs now. AGC members report higher trucking, disposal, testing, consulting, and insurance costs. Landfills are refusing PFAS suspect materials like dirt, forcing longer diesel-burning hauls to hazardous disposal sites. PFAS concerns are also disrupting recycling and beneficial reuse practices, increasing contractors' reliance on costlier virgin materials. And insurance is retreating. Many contractors are now seeing PFAS exclusions, higher deductibles, and low sublimits in their policies. These costs ultimately mean higher infrastructure costs that fall on American taxpayers. We can't build America's infrastructure on liability quicksand. EPA has not given us the numbers we need to know when construction materials like soil and recycled asphalt are safe to reuse, or instructions on how to manage or where to dispose of PFAS-impacted soil, groundwater, or other construction materials encountered during routine work. In that vacuum, some project owners choose not to test at all, shifting downstream risk to contractors who can't detect PFAS and can't insure against it. EPA asks contractors to trust its enforcement discretion, but discretion is not a defense, and it can be withdrawn at any time. This uncertainty is already discouraging bidders, especially on PFAS suspect projects like airports and military installations. With fewer qualified and competitive bidders, prices rise and taxpayers ultimately pay more. Administrator Zeldin recently acknowledged that CERCLA's passive receiver problems require congressional action. AGC agrees. Contractors who incidentally encounter PFAS should not be treated as PFAS polluters under CERCLA. AGC respectfully urges Congress to take 4 steps. Amend CERCLA to protect innocent contractors, formally recognize them as passive receivers who should not be treated as CERCLA polluters. Direct EPA to issue clear PFAS disposal and reuse standards so contractors have a lawful path to manage PFAS-impacted soils and groundwater. Require PFAS testing early in federally funded project planning so risks are known before bid time and costs can be accurately estimated and fairly allocated in construction contract. Ensure PFAS policy does not drive up infrastructure costs by clarifying liability, reducing uncertainty, and preventing runaway bid premiums on public projects. Contractors are ready to help address PFAS, but today they are being asked to take on immediate costs with no lawful path to compliance. You cannot comply with standards that do not exist. You cannot ensure a risk you cannot define, and you cannot build affordable infrastructure on limitless liability. Congressional action is necessary to provide a lawful compliance path and ensure America's infrastructure can be built safely and affordably. Thank you.
Thank you very much. And our final witness is Kate Bauer, Supervisory Attorney for the Congressional Research Service. Ms. Bowers specializes in environmental law, including the Comprehensive Environmental Response Compensation and Liability Act, referred to as CERCLA. Ms. Bowers, I welcome you back to the committee. Thank you for coming back, and thank you for being here, and you're recognized for 5 minutes.
Chairman Capito, Ranking Member Whitehouse, and members of the committee. Good morning. My name is Kate Bowers. I'm a supervisory attorney at the Congressional Research Service and our American Law Division. Thank you for inviting me to testify on behalf of CRS. In my brief remarks, I'll be addressing some of the implications of EPA's designation of 2 per- and polyfluoroalkyl substances, or PFAS, that's PFAS and PFOA, as hazardous substances under the Comprehensive Environmental Response Compensation or Liability Act, also known as CERCLA or Superfund. My testimony will also address EPA's CERCLA enforcement discretion and settlement policy with respect to those designated PFAS. CERCLA authorizes EPA to clean up contaminated sites and to compel entities that bear responsibility for contamination at a site to perform or pay for cleanup activities. Private parties that incur cleanup costs may seek to recoup those costs from other parties or from the Superfund trust fund. This framework is intended to ensure that there will be responsible parties who can bear the cost of cleaning up contamination, and that all responsible parties who are able can be required to share in those costs. In April of 2024, EPA announced a final rule designating PFOA and PFAS as hazardous substances pursuant to CERCLA. Designation does not trigger a cleanup action to address PFAS contamination at any site, nor does it cause PFOA and PFAS to be addressed or regulated under other federal environmental statutes. Designation under CERCLA also does not impose cleanup standards or requirements for the treatment, storage, and disposal of wastes containing PFOA and PFAS. Instead, the treatment, storage, and disposal of wastes is generally regulated under a different statutory scheme. Among other things, designation under CERCLA does unlock the full suite of EPA's CERCLA cleanup authorities and subjects releases of PFOA and PFAS to CERCLA's liability framework, but it doesn't determine any party's liability. For a party to be liable for cleanup costs under CERCLA, several requirements must be met. There must be a release or threatened release of a hazardous substance into the environment. There must also be a response action and response costs at the site. And only certain categories of parties with a connection to the contamination can be held liable. Those parties are often called potentially responsible parties, or PRPs, and they include current owners or operators of a site, past owners or operators, arrangers, and transporters. Parties may be liable under CERCLA for cleanup costs, injury to natural resource damage assessments, and federal public health studies, but not for products liability, personal injury or property damages, or health effects or medical costs. Under current law, CERCLA contains some statutory defenses from and exemptions to liability that may limit the liability of parties that meet certain criteria. This includes an exemption for releases or discharges that are in accordance with permits issued under other specified federal environmental statutes. CERCLA allows any person, including EPA, states, local governments, tribes, and private parties, to sue a PRP to recover response costs that they've incurred. It also allows a party that has been required to pay response costs to assert a contribution claim to compel other PRPs to bear an equitable share of those costs. PRPs that have resolved their CERCLA liability to the United States or a state in a judicially approved settlement cannot then be held liable for contribution claims by other PRPs regarding matters addressed in that settlement. Concurrent with the final designation, EPA issued a PFAS enforcement discretion and settlement policy memorandum, explaining that it intends to focus its enforcement efforts on entities that significantly contributed to the release of PFAS in the environment. Consequently, the agency does not intend to recover cleanup costs from certain categories of entities. That includes water utilities, municipal landfills and airports, local fire departments, and farmers, or where other equitable factors don't support enforcement. By itself, EPA's decision not to pursue enforcement would not necessarily protect those entities from enforcement action by states or from third-party lawsuits from entities who themselves have been held liable for response costs and are then seeking to recoup those costs from other liable parties. But EPA has explained that it intends to use the CERCLA settlement process to protect entities from such suits, which could address that potential outcome. Specifically, the agency stated in the memorandum that when it enters into settlement agreements with major PRPs, it would seek to secure a waiver of rights that would prevent the settling PRP from pursuing contribution claims against certain non-settling parties. EPA also stated that it may enter into settlement agreements with parties that are covered by the settlement policy in order to provide them with contribution protection. Thank you, and I will be happy to answer questions.
Thank you very, very much. And I'm going to begin the questions, and I'm going to start with you, Ms. Bowers. As I outlined in my opening statement, EPA and Congress worked together to resolve liability issues with brownfield sites as a model of how we should work together on PFAS contamination. In that case, EPA relied on existing administrative tools to manage third-party contribution risk, while Congress considered whether a statutory fix was warranted. The EPA has suggested it might take a similar approach here, using settlement agreements to protect entities unintentionally swept into CERCLA liability. My question is, does the EPA's brownfields experience offer a useful precedent?
Thank you for that question, Chairman. It may. Prior to the Brownfields Act in 2002, which amended CERCLA, there was no specific exemption codified in statute for what's referred to as bona fide prospective purchasers. So prior to 2002, EPA used its enforcement discretion, just as it's indicated it intends to do with respect to designated PFAS. And it used that enforcement discretion in a few ways. The agency had issued guidance, and it developed a model agreement for prospective purchasers of contaminated property where an EPA action had been taken or was ongoing or was contemplated. And what EPA then did was enter into prospective purchaser agreements. These functioned and often contained covenants not to sue to protect those bona fide prospective purchasers from liability. The agency also issued something called comfort letters or status letters that related to and contained information about EPA's intent to pursue enforcement or not at a site. So again, there are some similarities to what EPA has indicated it would do with respect to PFAS, entering into settlement agreements to provide protection from third-party contribution claims, requiring waivers of rights in settlements with major PRPs, would certainly also be options, as EPA has indicated, for limiting the liability of categories of parties.
Thank you. And both of you, I have this question. Without clear PFAS disposal standards, landfills are refusing materials due to inconsistent acceptance criteria. We've already covered this in all of our statements. Routine construction debris is now being hauled hundreds of miles. Imagine that. environmental impact across state lines simply because hazardous waste facilities are the only ones who will accept this material. This policy failure is driving up costs, overwhelming limited hazardous waste capacity, and generating unnecessary emissions from the long-haul diesel trucks. So what do you, I'll go to you, Ms. Pilconis first. What do you need to see from EPA's forthcoming disposal guidance to better manage this pathway?
Thank you for the
start with you.
question. So EPA does have destruction and disposal guidance out now, but it does not give contractors any actionable steps that provide any sort of certainty in the field. Where contractors have experience dealing with hazardous materials, lead, asbestos, PCBs, for example. But in that case, the construction industry is operating under a well-defined federal EPA playbook, laying out how to manage and dispose, laying out standards. That's what we need to see from EPA. We need clear risk-based thresholds. EPA needs to set background levels. We need concentration limits that will tell us and distinguish between restricted and unrestricted uses. Without that, contractors don't know whether PFAS-impacted soil is actually contamination or whether it's acceptable for reuse. We also need clear disposal instructions. Contractors need to know which types of landfills can accept PFAS-impacted materials and under what conditions. As we've discussed, many landfills are turning away PFAS-suspect soil by default, so we're stuck with higher costs, longer hauls, project delays. Without national consistency, clarity, PFAS uncertainty is going to continue to inflate bids, disrupt competition, and increase infrastructure costs for taxpayers.
Mr. Gerstenberg?
Thank you, Chairman Capito. At Clean Harbors, we've done extensive analysis and testing, much of it with the EPA as well as the Department of War. We've outlined criteria in our written testimony. That is the criteria that Leah is referring to that is needed by the EPA to release standards of thresholds that can be achieved for the safe cleanup and disposal of PFAS. We've outlined standards for high-temperature RCRA thermal incineration. We outlined standards for Subtitle C landfills, as well as Subtitle D landfills, industrial water, and drinking water. Those standards are based on science that has been accomplished over the past 20 years researching PFAS. We believe it is now time to lay out that guidance, those threshold levels, so that they can be used in the environment to help protect human health in the environment.
Thank you. I have a vote over on commerce, and I'm going to turn it over to Senator Husted, but I just want to make one quick comment. Kind of what I hear bleeding through all of this and what concerns me is you hear that guidance was released in 2024. We know that guidance can change from administration to administration, and obviously it hasn't been specific enough guidance because there's still a lot of gray area there. And so hopefully working with you all, we can find something that EPA can go to in a very permanent way. Because I think, Ms. Bowers, you said something like a letter of assurance or something from the EPA. What was it? Comfort letter. There's a lot of people in this country that don't want a comfort letter from the EPA, I can tell you that, because that's kind of hard to imagine in some sense. But in any event, a comfort letter wouldn't probably give much certainty to a lot of the businesses and others that I think you all are expressing here. So thank you for being here. Hopefully I'll make it back from my vote. Thank you.
Thank you.
Senator Whitehouse.
Thanks, Chairman. I assume all of the witnesses agree that PFAS is a dangerous substance. Is that correct?
Correct.
Ms. Pilconis, correct?
At certain levels, I mean, when we're talking about lightly contaminated PFAS soil, I guess we need more data and research on it.
But it's a dangerous substance. Correct.
Yeah, as EPA indicated in its designation of PFAS, the agency has found that it may present a danger to human health and the environment.
And do you all also agree that the prospect of liability is one motivation to clean up that dangerous substance. Agreed?
Yes, we do, agree.
Ms. Pilconis?
Threat of liability is what is increasing the costs.
But it also is assuring the cleanup. Correct? It's a motivation to do the cleanup? You can't agree with that?
I think it's the EPA designation of the sites will trigger certain cleanup. Threat of liability will cause an increased focus on PFAS, and now it's a fear of whether or not certain materials are going to rope you into Superfund, strict, joint, and several liability.
Ms. Bowers?
Liability certainly could be, or potential liability
A
certainly
motivating
could
factor,
be,
isn't
could
it?
be a motivation, depending on who's performing the cleanup.
Where you have a site that has been contaminated with PFAS, the easy way out would be to just let the poisoned community or neighborhood or facility bear the cost of that contamination in harm to people who live in the community, live in the neighborhood, or use the facility, and would bear the cost in their own health and safety harms. That's obviously not a great solution, and that's the reason that Congress did RCRA, because leaving it to the local community to be poisoned is a bad plan. So we want to make sure we don't work backwards to having these exemptions reopen the path to local communities being poisoned. Do you all agree that exemptions from liability can, if they're done wrong, transfer the harm or cost of PFAS back to the public, as opposed to transfer it among the responsible parties?
Well, we believe, Senator, that very similar to what has happened with CERCLA and Superfund, that the polluter should pay, and that there is sampling and analysis based on what's happened in that environmental area, that contaminated area, that can be traced back to the original polluters or contributory polluters of that area, so that the polluter will pay.
And Ms. Pilconis, it's not the intention of your testimony to transfer the danger of harm related to PFAS back to the exposed public, is it?
No, I mean, we agree with the polluter should pay.
Great. And Ms. Bowers?
When certain parties are exempted from liability under CERCLA, that does, just as a general principle, reduce the number of parties that may be available to pay for cleanup costs.
And the question is, does that additional burden of cleaning it up move to other responsible parties, or does it get dumped back on the community, the facility, or the neighborhood that has been poisoned? I would also make, my time is running very short, so let me just say, I'd also make the argument that not only can this be a shift from responsible parties back to the potentially poisoned public, but it can actually worsen the danger if it limits the liability incentive to actually do the cleanup work. So I hope that we can all agree as we work through this problem that two very bad outcomes of our work would be to move liability from responsible parties to the public in the form of additional poisoning and public health harm, or worse still, to not only move that burden back to the public, but to worsen that burden to the public, because the responsibility for the cleanup will have escaped the responsible parties and made things worse. So those are the things I'd like to make sure we avoid, and appreciate my time has expired.
Okay. I appreciate all of you being here today, and I'm trying to understand PFAS and how to do something about it. And this is not why you're here to testify, but it's amazing to me how many products still today are made with PFAS in it, yet we're talking about how harmful it is as a chemical in high quantities, even though it's part of the things that we serve our food, cook our food, all of those things are happening today with PFAS. And it seems to me from being involved with issues over the years where we wanted to clean up things that we later discover are harmful, that we have to find the most cost-effective ways to do that, because in the absence of a cost-effective way to do it, they'll just sit there and no one will do anything about it. And no one will accept responsibility and no one will move to take care of them. And I became aware of this issue several years ago in talking with the folks in Columbus at the Battelle Institute, who have done a great deal of research on PFAS and the implications of what it would take to clean that up. They have been at the forefront of advancing some innovative PFAS technologies and solutions to address these issues. Battelle created a spin-off company called Revive Environmental that has a technology called PFAS Annihilator that actively destroys tens of thousands of gallons of AFFF, which I understand is the ingredient that needs to be, or the element that needs to be destroyed. And they've done this successfully in states, airports, for commercial customers, and I'm sure that there are other ways to do this. What are, I'll start with you, Mr. Gerstenberg, what are the most cost-effective ways to deal with high concentrations of PFAS and destroy them so that we can move this process forward?
Thank you for the question, Senator. We believe that high-temperature RCRA-permitted incinerators are cost-effective for AFFF. And today, we are actually managing and disposing the change-out of fire department equipment and systems cost-effectively through that solution. We believe that the other technologies that are being developed, such as you mentioned, that Battelle has been working with, is not scalable nor cost-effective. However, existing technology that exists throughout the United States is and can be for highly contaminated materials, such as AFFF. We have participated in plans with states to remove AFFF from fire departments. Just yesterday, we had a piece of fire department equipment at one of our Braintree, Massachusetts locations being cleaned out and flushed. So that capability is out there today, it exists, and it is cost effective. Now, I think the important thing to revert back to is that there is levels of thresholds based on science that can be laid out by the EPA that can allow people to act. Things in the parts per million and parts per trillion, and we don't need to go down the gory details, or we could if we wanted to, of suggested levels based on the science that could be set that dictate cost-effective remediation, such that when infrastructure is being built, Subtitle D landfills will accept PFAS contamination at light levels. At high contamination, RCRA-permitted incinerators are cost-effective. There's not enough of it out there that it would drive a price tag that is beyond anybody's ability to manage.
Okay, and so you've conducted mass balance analysis of your hazardous waste incineration, and you have the results of that?
Correct, and they were recently published by the EPA. The EPA was an active participant, as well as the Department of War, participated in the sampling and studies, as well as third parties, to validate all the information, and that was publicly released just recently in September. And it proves, based on the most updated standard, that high temperature RCRA permitted incinerators, RCRA permitted, I want to emphasize that, because they're not normal incinerators. They're EPA approved. They have 9 base criteria that must be managed properly. We're highly regulated by the EPA.
So I would just conclude with this, is that one of the things that we often confront in environmental cleanups is who's liable for it, how do you fix it, where does the money come from, but I also know that I'm typically not a fan of a one solution approach. I know that there are a lot of people out there looking at different ways to do this, but I hope that the EPA will continue to aggressively test the different solutions, that we will find out which ones are the most cost-effective, and then provide that regulatory certainty about liability, who's responsible, how we clean it up, and then how we absolve people of liability once it is cleaned up in a timely fashion. So, Senator Blunt-Rochester.
Thank you, Mr. Chairman, and thank you to the witnesses for being here today. The development of thousands of PFAS varieties have become a part of modern industries, from corrosion preventing coatings in our electronics, automobiles, and medical devices, to safety applications such as firefighting foams that keep us safe. PFAS is now part of our world. But these advancements have come with a cost. Without proper disposal, these chemicals contaminate our soil and water, putting our communities at risk for increased rates of serious health conditions, including cancer, infertility, and birth defects. We need to work together to protect the public health and the environment from PFAS. My first question is for you, Ms. Bowers. Prior to the designation of PFOA and PFAS as hazardous substances, how did EPA handle the cleanup of these pollutants at Superfund sites?
Thank you for that question, Senator. Prior to the designation, PFAS and PFOA were not considered hazardous substances under CERCLA, and so cleanup authority to address them was more limited. I should note that it's common for more than one contaminant of concern to be present at a cleanup site under CERCLA. And so it may have been the case that where PFAS was co-located with other contaminants of concern, it may have been cleaned up or addressed incidental to other contaminants. But prior to designation, EPA's response authority to address PFAS would only have been available to address an imminent and substantial endangerment to public health or the environment.
And how will the new designations change the way cleanups are conducted at Superfund sites?
Thank you. The cleanup process remains the same as it was. EPA would typically begin by investigating and assessing the nature and the extent of the contamination and identifying potentially responsible parties. Cleanup of the newly designated PFAS could be at sites that are already being cleaned up or have already been cleaned up under CERCLA. It could potentially be identified and be cleaned up at new or additional sites as well.
I know EPA has historically focused on the parties most responsible for pollution. What tools does EPA have to support potential passive receivers like airports or water utility companies that are either required by law to use PFAS or unaware of PFAS contamination?
Thank you. As was mentioned in the opening remarks, CERCLA is a strict liability statute, which means that liability under CERCLA attaches regardless of intent, knowledge, or prior legal regime. As I had mentioned earlier, EPA does have enforcement discretion at its disposal. Under CERCLA, the agency can decline to take enforcement action with respect to passive receivers. It's indicated an intent to do so, and also to use the settlement process to provide some protection. I would also note that it's very common for passive receivers to be regulated under other federal environmental frameworks as well, possibly most significantly for purposes of this hearing, the Clean Water Act and RCRA. If entities are discharging or releasing a hazardous substance in accordance with or in compliance with a a specified federal environmental permit, including certain permits under the Clean Water Act and under RCRA, that release is considered or can be considered a federally permitted release under CERCLA. And federally permitted releases are exempt from liability specifically under the CERCLA framework. So that is something that is a very fact-specific inquiry, but could potentially apply with respect to certain passive receivers.
And Mr. Gerstenberg, as you mentioned last year, Clean Harbors conducted a PFAS incineration study in partnership with the EPA's Office of Research and Demonstration and the Department of Defense. Can you discuss how your PFAS incineration process prevents air and water pollution? And as a follow-up, how are you using it to monitor systems to ensure the safe destruction of PFAS?
Yes, thank you, Senator. The disposal testing that we did was at our high-temperature RCRA permitted incinerator in Utah. And there were very stringent monitoring devices that were put throughout the unit, understood the contaminant levels that were being fed into the unit, and were able to monitor the destruction all the way through the unit and through the very advanced pollution control systems that are put on the back end of the unit to assure complete destruction of 6 nines and 2 to 8 times below any thresholds for ambient air monitoring. So we were able to monitor that.
Thank you. My time has expired, but I have additional questions that I will submit for the record. Thank you, Mr. Chairman. I yield back.
Senator Ricketts.
Thank you, Mr. Chair. I want to thank also Chairman Capito and Ranking Member Whitehouse for holding today's hearing, as well as our witnesses for appearing before us here today. Nebraskans have shared concerns about PFAS. The family of chemicals plays an essential role in everyday lives of Nebraskans. Biosolids are used as fertilizer on farmers' fields. Fire suppression foams are crucial for emergency response at airports. Some specific chemicals are likely harmful. PFOA and PFAS have already been regulated under the National Drinking Water Act. This administration is working hard to uphold the standards that protect Nebraskans while also providing common sense solutions for the high costs. Common sense solutions such as additional time for compliance with new rigorous standards will help small water systems like those in rural Nebraska. Common sense solutions should always be used as we try to tackle difficult problems. One of those difficult issues is PFAS cleanup. As you know, the EPA designed PFAS as a hazard, or designated PFAS as a hazardous substance under CERCLA. Without legal protection, this move creates significant risks for passive receivers of PFAS. Passive receivers are just everyday folks trying to serve their communities. That's why I introduced an amendment removing legal liabilities from passive receivers of PFAS. It's a common sense solution. Farmers, ranchers, rural water systems, and firefighters deserve to know that they are not on the hook for expensive cleanups of chemicals they didn't create. Administrator Zeldin has acknowledged that we need to provide certainty for these industries. Mr. Gerstenberg and Ms. Pilconis, should Congress enact legislation granting public water utilities, farmers, and other passive receivers of PFAS a CERCLA exclusion to protect innocent communities and ratepayers? Mr. Gerstenberg, would you please start?
Senator Ricketts, we believe they should, and we believe that the polluters should pay, and we believe that through sampling and analysis, we are able to trace back to who the polluter is.
And has that been typical of our policy at the government to say polluter pays?
Yes, through the typical RCRA hierarchy of PRP, potentially responsible parties, there is sampling and analysis that can be done to trace back to those polluters. There also is levels and threshold levels of disposal technologies that can be utilized based on background levels, high concentrations, and that's what we need, as we included in our written statement, those thresholds, suggested thresholds, to be able to be acted upon to be able to move on the cleanup of PFAS.
Great, thank you. Ms. Pilconis?
Yes, thank you, Senator. Contractors need passive receiver protections to prevent them from being responsible for the full cost of cleanup where they incidentally encountered PFAS during the course of ordinary construction. PFAS has been used for decades. It's everywhere. There was not testing. Historic projects that contractors worked on going back decades could expose them to CERCLA liability today. So a disposal site that you took soil to 20 years ago could attach you to CERCLA cleanup liability 10 years from now. The other thing really unique about construction and why construction needs passive receiver protections is because unlike a fixed facility, construction firms work across America on hundreds of sites in every community, building roads, bridges, working on airports, military bases. We're excavating soil, we're moving materials, we're reusing aggregates, we're using many, many disposal sites. So that makes the PFAS Superfund exposure and the liability exponentially greater for construction.
Great, thank you. I understand innovative technologies are being used to address PFAS alternatives. The use of soybean meal is one of those promising opportunities as it can be used as an alternative for firefighting foam such as PFAS. The foam is 84% bio-based and is certified under the USDA's BioPreferred program. Supporting these innovative alternatives will not only create new markets for our soybean farmers, particularly concerned of somebody from Nebraska, but also has the potential to replace PFAS-based firefighting foam while performing just as effectively for some fires. And with that, Mr. Chairman, I'll turn it back over to you. Thank you.
Thank you. Senator Padilla.
Thank you, Mr. Chairman. Good morning. I appreciate your participation today in this hearing. I have two specific questions regarding the potential liability of, quote, passive receivers, including municipal water and wastewater districts for PFAS under CERCLA. EPA's enforcement policy is to refrain from bringing actions against these municipal entities. The municipalities, however, remain vulnerable to third-party actions seeking their contribution to response costs. The municipalities can attempt to defend against such third-party actions by reaching settlements or de minimis settlements with EPA that protect them from third-party contribution actions. Rob Fox, a leading CERCLA attorney, testified in this committee at a hearing on PFAS liability last year that a Supreme Court case has ended settling passive receivers' ability to defend against third-party claims. And specifically, in the Atlantic Research case, the Supreme Court stated that third parties could bring cost recovery actions under Section 107 of CERCLA against settling passive receivers, even if they were barred against bringing contribution actions under Section 113 of the statute. I know it's getting very technical here, but this is important. The case raises significant questions about what proportion of potentially responsible parties can seek cost recovery claims and the extent to which a court, using its equitable discretion, would reduce any liability for settling passive receivers. Ms. Bowers, I understand you're still researching the issue, but can you provide some initial thoughts on how the Atlantic Research case affects passive receivers' ability to defend against third-party claims?
Thank you for the question, Senator. As you noted in the question, there are two different types of actions to recoup cleanup costs under CERCLA. There are cost recovery actions under Section 107A of the statute and contribution claims under Section 113. Which parties are able to bring claims under which is probably a little bit more technical than we can go today, although I will note that when a party is able to bring its claims as a contribution claim, which is typically when a party has itself faced liability, it is barred from bringing a Section 107A contribution cost recovery claim. It's also correct, as you note, that EPA's enforcement discretion policy, as well as CERCLA's contribution protection provision in Section 113F of the statute, provide protection from claims for contribution. The question of whether there are additional claims that passive receivers may potentially face liability for outside the universe of contribution is a difficult one to answer and would require pretty intensive analysis of the nature of the settlement with EPA, the claims that are being brought against that passive receiver, as well as how a reviewing court, whether and how a reviewing court applies any equitable factors to evaluate the extent of that passive receiver's liability for response cost. I would be happy to discuss this further in response to additional questions.
Yeah, and we'll definitely take you up on that offer, because as you can imagine, there's no shortage of local governments, wastewater, and municipal water service providers that have shared this concern, not just with my office. I know my colleague, Senator Schiff, as well. Maybe this is a follow-up in the time remaining, and this is for each of the witnesses. How well do potential settlements with EPA protect municipalities and others from actions by third parties? And I guess what specific circumstances concern you if you don't believe the municipalities and other parties are sufficiently protected? We'll start with Mr. Gerstenberg.
Well, we believe that certainly based on science, that you can trace back to the polluter who initiated the PFAS contamination. We believe there's cost-effective solutions to be able to support. There's funding that's been released, $2 billion under the government, to be able to help wastewater treatment plants, as an example, begin to put treatment systems in. There's also funding from settlements with large companies such as 3M. There's funding that exists, and we believe that there's difficulty accessing that funding. People are not readily aware of how to get to that, to put treatment systems in to help protect human health and the environment.
All right, to be continued. Ms. Pilconis?
Yes, thank you, Senator. Settlements are just one tool in the toolbox, but not a solution in and of itself. They're site by site. There's no guarantee they'll be offered. It's at EPA's choice, and they don't provide the upfront certainty or the nationwide relief that contractors need. If a contractor's talking to an EPA attorney about a settlement agreement, it means they're already in the mix as a potentially responsible party, and that's not where contractors want to be. It means lawyers' fees. It means expending company resources. Contractors would still need to buy peace. It doesn't fix the liability problem. Also, settlements with large contributors could actually make things worse for contractors, particularly if they're broad. It could make contractors and other downstream parties more exposed to full CERCLA liability and take away contractors' cost recovery rights.
Ms. Bowers?
Senator Curtis.
Thank you.
Oh, Mr. Chair, did Ms. Bowers want to also briefly respond to the second question?
Sure.
Thank you. The question of whether the protection that's afforded by EPA's settlement with a passive receiver, whether that's adequate, raises policy considerations that are beyond the scope of what I'm able to testify to in my capacity as a CRS attorney. What I can say is that it is difficult at this point to identify the specific fact patterns under which a party that receives contribution protection under CERCLA would still face liability under CERCLA. I would note, though, that even with protection from liability under CERCLA, parties may still potentially face liability under other federal or state laws.
Okay. Thank you very much. Thank you, Mr. Chair.
Senator Curtis.
Thank you. Congress has a responsibility to ensure that PFAS cleanup policies are grounded in science, workable for local governments and businesses, and fiscally responsible to taxpayers. As we advance national cleanup standards, we must ensure that the burdens do not fall unfairly on pass-through entities such as contractors, municipal utilities, small engineering firms, recycling facilities, and others who may have handled PFAS-containing materials as part of their normal operating, contributing to the contamination. These entities are essential to building and maintaining our water systems, but when liability or compliance costs fall on them, those costs ultimately flow through to families, homeowners, and the broader housing market. In Utah, we're struggling to be able to buy homes, our children. So, Ms. Pilconis, Utah is facing a real affordability crisis. Many people who have lived there their entire lives in Utah can no longer afford to buy a home. How does CERCLA pass-through liability, especially for contractors and water districts, affect the overall cost of building and maintaining homes?
The costs that AGC is familiar with and that we included in our written statement, I think would equally apply to home building work. PFAS is everywhere. It's even found in rural communities. So the increased costs that contractors are facing with regard to disposal costs, higher material costs because they're unsure if they can reuse soil or reuse aggregate, the tightening insurance market, the issue with taking on more risk in contract. All of that without a way to price, to share, to transfer risk. The prices, these bid prices, the home building prices, the prices of infrastructure, the decrease in qualified bidders. This is happening now. It's happening with federal infrastructure. Same could apply to cost of home building.
Good. A follow-up, if I may. What solutions should Congress consider to protect people from exposure? We can all agree that we want to do that, but while also taking into account new research showing that not all PFAS derivatives pose the same level of harm. Could there be, for instance, thoughtful exemptions?
Congress can protect innocent contractors from being treated as potentially responsible parties when they incidentally encounter PFAS. They could also require PFAS testing early in federally funded project planning so contractors know the risk before bid time.
Thank you.
Administrative action alone is not going to solve this problem. EPA can't change CERCLA's strict, retroactive, and joint and several liability.
Thank you. Mr. Gerstenberg, your Clean Harbors technology is very impressive, but expensive. What legislation or regulatory actions could help lower these costs so that smaller, rural, and low-income water districts like many in Utah can realistically access this technology? And is there any component for university partnerships that may be a part of this? And I'd love just to know your thoughts on that.
Thank you, Senator. Well, we believe that there is well-founded science to be able to put thresholds based on contamination levels of what has to go to a high-temperature incinerator versus a subtitle C landfill or a subtitle D landfill. We believe those thresholds need to be put in place. And based on the science, there is cost-effective solutions for being able to build homes and be able to excavate that soil and manage it to a lower cost technology than high temperature thermal incineration. That science just needs to be released and those thresholds can be put there. They can still protect the human health and the environment and be executed on cost effectively. I think the breakdown is that those standards have not been released yet so that contractors such as performing the construction know that they can take it to a subtitle T landfill without driving up exponential costs.
Thank you. Ms. Bowers, maybe tying into this a little bit. CRS has done great work. Have you done any additional research identifying which PFAS derivatives are harmful and at what concentration levels they present risk within the water system so that perhaps we could deal with this issue?
Thank you for the question, Senator. The specific properties and the effects of different PFAS is beyond the scope of my expertise as an attorney at CRS. I would be happy to follow up with some additional colleagues and see what we can find in the literature regarding the effects of PFAS.
Thank you. And to his point, I think that would be very helpful to members of the Senate. In CRS's research, how impactful are the high-cost mitigation or destruction systems in reducing risk?
So that I'm sure that I understand your question. You're referring to those mitigation and treatment systems specifically with respect to PFAS? I don't know the answer to that question, but we would be happy to look into it.
Okay, good. Thank you. Thanks to all of our witnesses. Thank you, Chair. It's a great hearing, and I yield my time back.
Thank you. Senator Schiff.
Thank you, Madam Chair. I share the concerns that many have raised about the potential liability to water and wastewater systems that are passive recipients of PFAS and have played no role in that PFAS pollution, but could be on the hook for compensation for cleanup. At the same time, there have been some concerns raised about blanket exclusions and whether that sets a precedent that could lead to more blanket exclusions or that it might impede cleanup efforts in which water systems are provided resources to help with the cleanup process. So two questions. One, Ms. Bowers, can you articulate any concerns over a blanket exclusion of passive recipients? And Ms. Pilconis and Mr. Gerstenberg, if you could comment on what about an approach that would codify the EPA's policy of shielding de minimis entities from third-party litigation if they're acting in good faith? Would the current policy expressed during the prior administration of not enforcing these actions, if codified, would that provide sufficient protection for these passive recipients?
Thank you for the question, Senator. The question of whether whether a liability exemption under CERCLA statute would have unacceptable effects, or by contrast, whether the level of risk remaining to passive receivers absent an exemption would be unacceptable, requires some policy balancing that I'm not really able to speak to. What I can say is that to date, Congress has not enacted a liability exemption that would apply with respect to a specific substance. The liability exemptions that Congress has enacted have applied to categories of parties, types of activity, but they have not been chemical specific in the way that that an exemption for PFAS liability would be. I also noted in response to an earlier question that there may be some consideration around potentially reducing the overall number of parties that would be liable under CERCLA and that would be available to pay for all or a portion of response costs. Again, that's a policy balancing that would be for Congress to decide.
Okay, thank you.
Right. PFAS is very different. It's ubiquitous. It's already in groundwater, already in soil, consumer products, building materials. The contamination is largely historic. We're not talking about a spill. It's invisible. You can't smell it. You can't see it. It's unavoidable. Contractors work across, as I said, hundreds of sites, using hundreds of landfills, reusing materials over decades. CERCLA was not intended for chemicals this widespread, or this persistent, or this impossible to avoid. And for other chemicals, we have clear standards. We have clear background levels, concentration limits telling us what are restricted versus unrestricted use, and disposal guidelines and requirements. We don't have that for PFAS.
And is that a problem with the fact that the regulatory agencies haven't moved quickly enough to provide those kind of limits for PFAS? Is it, I know there are certain types of PFAS that are more difficult to measure and maybe the science isn't there yet, but is that a problem with regulatory inaction or something unique to PFAS?
It's a big problem that we have designated two of the most ubiquitous PFAS chemicals as hazardous substances under CERCLA, which is attaching that strict joint and several retroactive liability to anyone that has touched it when we don't have any standards to manage it.
Mr. Gerstenberg,
Thank you, Senator.
What would you think of an approach that codifies the regulatory discretionary policies expressed previously?
Yes, so first, I'd like to reiterate, Senator, that we believe there has been enough science accomplished to be able to put out standards for regulatory cleanup and thresholds around that can be enacted on. And those need to be put in place the sooner the better. Once those are in place, we can make sure that we protect passive receivers of the materials and focus on the polluters of PFAS. We just think that those standards need to be put in place so people can act.
Do you have any view about the relative merits of a blanket exemption versus codifying the policy of the previous administration not to go after de minimis and
yes, I think that that there should be exemptions around de minimis amounts of PFAS. and that passive receivers should be protected from liability.
Okay. Thank you, Madam Chair.
Senator Also Brooks.
Thank you so much. Thank you, Madam Chair. And I want to say thank you as well to the witnesses today for being here. Maryland has taken a particularly proactive approach to addressing PFAS contamination. Our state has conducted statewide drinking water testing, surface water sampling, and fish tissue analysis across the Chesapeake Bay watershed. And these efforts have helped to identify the causes for contamination long before many other states had comparable data. Maryland has made these investments so that responsible parties can be clearly identified and communities can benefit from cleanup. CERCLA is designed to ensure that the polluters, not the public, bear the cost of remediation. So my first question is for Ms. Bowers. I just want to ask you, how does CERCLA's liability framework support states like Maryland that have already done the hard work of gathering evidence and mapping contamination? And how does it help ensure that cleanup costs are properly assigned to the responsible actors?
Thank you for that question. CERCLA envisions a robust role for states. States are able to take enforcement action under the statute. States provide input into listing sites on the national priorities list of Superfund sites. States have a role in determining what cleanup is appropriate at a site. States also can enact their own, they're often referred to as mini Superfund laws, so their own parallel statutory or regulatory schemes under state law for addressing contamination from various substances. And so many states have been addressing PFAS contamination under their own state laws prior to the designation under CERCLA of PFAS and PFOA as hazardous substances.
Thank you. And likewise, just another question for you, Ms. Bowers. In Maryland, some of the most contaminated sites we found are located at federal facilities like Aberdeen Proving Ground, the Patuxent River Naval Air Station, and other Department of Defense sites where firefighting foams that contain PFAS and industrial processes were used for decades. And so state sampling has repeatedly shown that these federal facilities are among the largest contributors to PFAS contamination in the Chesapeake Bay watershed. And Maryland has been working to address this contamination, but the state ultimately relies on EPA's enforcement of CERCLA to ensure that federal agencies take responsibility for cleanup in the same manner as private entities. And so I wonder, how does CERCLA ensure that federal facilities are held to the same cleanup standards and obligations as private polluters, and what mechanisms are in place to make sure that federal agencies fully participate in remediation in a timely manner when they're identified as responsible parties?
Thank you for that. Under CERCLA, federal facilities and the federal government face the same liability and the same requirements as other sites. In addition to that, with respect to military sites, DoD remediates environmental contamination under the Defense Environmental Restoration Program. And Congress has been requiring DoD to respond to and address contamination from pollutants, contaminants, and hazardous substances, which would have included PFAS and PFOA even prior to the designation of those substances as hazardous under CERCLA.
Okay, thank you. Ms. Pilconis, I just want to ask you a question as well. Restoration and navigation projects throughout the Chesapeake Bay region frequently involve dredging, and some of the dredged sediment has been found to contain PFAS, particularly near historic military installations, industrial sites, or wastewater outfalls. Handling and disposing this sediment presents unique challenges for contractors, including uncertainty around proper containment, transportation, and disposal, as well as potential regulatory liability. So I wonder, given these challenges, what specific guidance or technical support from EPA or state agencies would help contractors safely manage PFAS-contaminated sediment, maintain compliance, and avoid delays in project timelines?
So we need concentration thresholds so that we can understand restricted versus unrestricted use We need disposal standards so that we know what needs to be taken where. We can't take all soil that is involved in construction to a hazardous waste landfill. And in some cases, our members are being told that that's what they need to do because the closest municipal solid waste landfill won't accept the soil. We've gotten price differentials that I included in my written statement from our members, going from an example of a contractor had waste from a DOD facility. They were told that they couldn't take it to a regular landfill. Costs went from $20 a yard to $200 and $300 a yard. And we're talking about tens of thousands of yards of soil. In the Northeast, lightly contaminated PFAS soil, same thing, had to be hauled to a hazardous waste landfill 100 miles away. So the costs are increasing exorbitantly because we do not have the concentration thresholds and we do not have the instructions or the standards on what to take where. What does need to go to a hazardous waste landfill?
Thank you. And I have also a question, Mr. Gerstenberg. The need to address PFAS contamination is urgent, and incineration is one approach to destroy PFAS. However, there is so much uncertainty about the process, leading to concerns with this method. And the Argonite facility in Utah has a history of permit violations, including burning waste that contained mercury and lead. And so what has Clean Harbors done to prevent similar issues during PFAS incineration?
Yes, thank you, Senator. We've done extensive testing with the EPA, also with the state of Utah, in burning PFAS, and have proven through our high temperature RCRA incineration that PFAS can be properly disposed of, high concentrations of PFAS. High temperature RCRA thermal incineration is a higher cost, and that should be utilized around higher concentrations of AFFF foam in contaminated soils. In the cases that we were just talking about where remediation of dredging soils, those could go to a more cost-effective solution than hazardous waste incineration.
Thank you. Thank you.
Thank you. Senator Kelly.
Thank you, Madam Chair. And thank you, all of you, for being here today. As I've discussed in this committee previously, remediating PFAS contamination in Arizona's aquifers is an urgent priority. And I was happy to be here during Senator Alsobrooks' questions. I've got a couple more on the topic. In Arizona, in the face of long-term drought, groundwater remains a critical source of drinking water for so many communities across our state. And many of those communities even bank water underground to prepare for future shortages. But now we face a serious challenge from PFAS contamination in many of those aquifers. In Tucson, for example, PFAS has forced the city to shut down nearly 30 groundwater wells, resulting in more than $71 million in cleanup and treatment costs. So clearly, there is a problem here that we need to solve. CERCLA, as was previously mentioned, sometimes known as the Superfund law, has shown promise as a tool to address these challenges. Last October, EPA approved an Air Force plan to ensure safe drinking water and undertake PFAS cleanup efforts in Tucson, where my wife and I live, and my granddaughter lives. Under that agreement, the Air Force will work with the city of Tucson to investigate PFAS releases from nearby facilities, yet the Department of Defense is still dragging its feet, delaying this and other cleanups nationwide for years. Without CERCLA, though, these cleanups might not happen at all. So my question to each of you is CERCLA the proper tool to address our nation's PFAS contamination problem? And if it isn't, what authority should Congress leverage instead? We'll start with Mr. Gerstenberg.
Thank you, Senator Kelly. We believe that CERCLA is a good foundational tool to be able to address it in similar stances of the RCRA regulations that were put in 1976. We also believe that it is time to act. It is time to put thresholds and contamination levels in place by the EPA such that the bases that you were just referring to need to act, so it just doesn't sit there and contaminating drinking water in the ground. And we believe there is a way to act. There is a safe way to manage, treat the water cost effectively and dispose of it and clean up these sites. But what we think those thresholds of contamination levels based on what that has been exposed to needs to be enacted and put in place so that Department of Defense military installations will act accordingly.
So CERCLA, you think is the right thing, you just need the trigger to start using the tools that CERCLA provided. Ms. Pilconis.
Thank you, Senator. My comment is simple, or similar. Contractors are on the front lines of cleanup and doing the remediation work. But for everyday infrastructure work and for the work that we're doing to repair and revitalize and rebuild our nation's infrastructure, they're incidentally encountering PFAS as a result of just doing that work. And CERCLA is making them potentially responsible for the full cost of cleanup because of the strict joint and several retroactive liability scheme. And right now, we have no lawful path to compliance. We have no numbers, we have no instructions or standards on how to dispose of material. We don't have restricted uses, we have no unrestricted uses, we don't know when we can reuse materials. So having the CERCLA scheme in place without having the proper roadmap to compliance, which we have with other hazardous materials, lead, asbestos, PCBs, we're in a very difficult and unique situation where contractors are exposed to extreme risk and liability. And contractors are touching soil and groundwater across America using many, many different landfills. So
So it
our
sounds
risk
like you
is
think-
exponentially increasing.
You think we need something specific to PFAS?
We need
Beyond
a lawful
CERCLA.
path to compliance.
Ms. Bowers.
Thank you, Senator. CERCLA is one tool in the federal legal toolbox to address PFAS. It is the broadest mechanism under federal law for requiring parties to perform or pay for cleanup actions. There are other enforcement authorities that are also available under federal law and may be applicable in particular situations. You mentioned the Tucson site, for instance. EPA, in addition to addressing issues under CERCLA at that site, has also taken action under the Safe Drinking Water Act. So that or other statutes may potentially be relevant. I would also note that statutes that focus on regulatory and compliance issues that establish permitting regimes and allow federal agencies or states to establish guidelines or requirements for entities that are potentially discharging PFAS into their environment as part of their operations, as well as statutes like the Toxic Substances Control Act that address manufacture and use of chemicals. These can all be relevant depending on what aspect of PFAS an agency is interested in addressing.
Well, thank you, Ms. Bowers. Again, thank you to the three of you for being here. And Madam Chair, I have a question I want to submit to Mr. Gerstenberg for the record, and thank you.
Will do. Thank you. Senator Markey.
Thank you, Madam Chair. Cities and towns around Massachusetts are grappling with the costs of building new water treatment facilities and are worried about the liability costs associated with PFAS. And they're putting in all this work and this expense for one reason, to keep people safe. Because when these toxic so-called forever chemicals build up in our environment and make their way into our food, our water, our bodies, we now know that they are connected to harmful effects. CERCLA, also known as the Superfund law, is a key piece of legislation that we used to fight back against toxic chemicals. I was in the room on the committee in the House of Representatives drafting Superfund. I brought the Woburn case to the committee so that they could see what was happening in Woburn, where company after company had just dumped all of these chemicals into the groundwater and ultimately into the water and into the lives of children catching leukemia, and other diseases, which were avoidable. That became the movie A Civil Action, the book A Civil Action, and that's what I fought for and introduced into the deliberation in 1980 on the committee against the will of all those companies that were fighting me in Woburn, Massachusetts, in the community which I represented. So it's been used over the years, and this is now a refrain that keeps coming back. The first Reagan administration, by 85, 86, they were trying to undermine Superfund. In the 1990s, they were trying to do it again. And so I know what this law means to communities and families around the country who worry about whether they're going to get poisoned with some company's long ago actions. So let's look at how it really works. Ms. Bowers, is it true that the Environmental Protection Agency, when enforcing the Superfund law, targets bad actors who are responsible for significant releases?
Yes, that's correct, Senator.
Yeah, they go after the actual polluters to clean up their own contamination, reduce potential litigation, costs on water utilities, and prevent an increase in water affordability. Ms. Bowers, in the 45 years since the passage of Superfund, has the EPA historically used its enforcement discretion when dealing with utilities and municipalities?
Thank you for that question, Senator. I don't have specific data on the instances in which the agency has used its enforcement discretion. That it may not necessarily be publicly visible when an agency has declined to pursue enforcement. What I can tell you, though, is that EPA has indicated in various enforcement discretion policies and guidance over the years since CERCLA's enactment that it typically seeks not to pursue municipal governments for cleanup costs under CERCLA unless there is some sort of extenuating circumstance.
Right. So the enforcement discretion has been utilized for a majority of the environmental cleanups with hazardous substances. And I'm worried about any efforts that would create loopholes in the statute of the landmark Superfund law, which has built-in protections to avoid those not responsible for releases from liability. Ms. Bowers, just to put a fine point on it, have we ever passed laws that exempt specific groups from the liability framework for certain chemicals under Superfund?
Thank you, Senator. Not with respect to specific chemicals, but Congress has enacted liability exemptions that would apply across the full suite of chemicals designated under CERCLA.
CERCLA already possesses a series of options for parties who minimally contribute to contamination between de minimis and de micromis settlements and ability to pay agreements. Entities can be safeguarded from liability that they should not have to incur. And EPA already has a wide variety of tools to protect parties who aren't responsible for pollution from undue liability. We actually need to preserve our polluter pay laws without putting huge potholes in it to trap us later on. So as we work to clean up the toxic forever chemicals already here, we have to stop new PFAS from getting into the environment. We're trying to bail out our boat without plugging the hole in the bottom. We're at risk of sinking no matter what. This is particularly true when EPA Administrator Lee Zeldin has yet to give any PFAS compounds a designation to standardized disposal procedures and has rolled back drinking water standards on PFAS compounds formerly set during the Biden administration. That backsliding undermines the Safe Drinking Water Act. There are hundreds of varieties of these compounds, and Administrator Zeldin won't even make steps towards a few of them. Meanwhile, the toxic stream of these products continues into our environment. We need to clean up our act across the board. That means stopping new toxics from getting in, supporting cleanup efforts in our towns, and focusing our energy on the companies that have been causing the damage. And if I may, Madam Chair, there are currently no federal regulations governing the incineration of PFAS, which can be sent to municipal solid waste incinerators, sludge incinerators, burn pits, and hazardous waste incinerators that are not designed for this purpose. Clean Harbors owns studies own studies show that effects of PFAS incineration depend heavily on temperature and operating conditions, and we know that many municipal incinerators operate at temperatures that cannot safely destroy PFAS. So, Mr. Gerstenberg, Massachusetts, thank you for being here. Would Clean Harbors support the designation of PFAS as hazardous waste under the Resource Conservation and Recovery Act, so EPA could establish uniform health protective standards for the disposal of PFAS-containing waste?
Thank you, Senator. Yes, we believe that high concentrations of PFAS needs to be disposed of in high-temperature, RCRA-permitted incinerators. Those high temperatures have been proven to properly destroy PFAS compounds. And so when limitations are put in play, those highly concentrated must be managed into incinerators that are regulated, highly regulated by the EPA and have proven that high temperature, not municipal incinerators, high temperature RCRA permitted incinerators have been proven to properly destroy PFAS.
Yeah, so this designation is merely a recognition of what we already know. PFAS is a dangerous substance that needs to be responsibly disposed of, and this would protect the health of the communities living in those areas. So we thank you so much for that testimony. We thank all of you. Thank you, Madam Chair.
Thank you, Senator. Well, I believe we have no further questions, so I would like to thank the witnesses. I think we got some great comments on the record that we can hopefully use to provide the certainty. The uncertainty is what is tying all of your testimonies together. Senators who wish to submit written questions for the record have until 5 p.m. Wednesday, December the 3rd to do so. I believe Senator Kelly mentioned he was going to submit one. The witnesses' responses to those questions are due back to the committee no later than 5 p.m. on Wednesday, December the 17th, and will be submitted for the record. With that, this hearing is adjourned, and thank you all very much.